2025 has started off with a bang. In today's episode, we are looking at the proposed changes to the Employment Relations Act, all the way through to changes around the minimum wage and even the holidays legislation. It's all happening, people. Businesses, buckle up, because this episode on employment law updates for 2025, this one, it's just for you. Hello, everyone, and welcome back to Lawlands. My name is Sanam, and thank you so much for tuning in to the Employment Law Done Right podcast. Hello, and a happy new year to everyone that celebrated. We are now officially a few weeks into 2025. How is everyone feeling? Hopefully not overwhelmed and settling back into work. I hope for everyone out there that did have some time off, you managed to have some nice R&R. You managed to go and see family, friends, and just have some time to yourself. For anybody that was working over that period, I hope you still managed to get some time in if you were celebrating anything over that festive season. There was a lot that was happening on my end. My family came to visit and all of that good stuff. We also went and visited my partner's family in Auckland. So it was great to be able to get around. Now, in terms of why we're all here for this episode, you might have seen this, and I'm sure you would have, especially if you're in the HR space and seeing what updates are coming out. The tail end of last year, there were a lot of changes being proposed and introduced by the coalition government. So I thought, why not take some time for us to sit down and go through all of these changes? Keep in mind, before we get into this, these are not changes that have been fully implemented yet. We are looking at proposed changes, proposed bills. Keep that in mind. And before we get into it, I have to say my spiel. If you're liking these episodes and if you love listening to the Employment Law Done Right podcast, please make sure you follow the podcast. And we have a lot of fun things rolling out for Lawlands over the next coming weeks. Keep your eyes peeled for that. If you want to stay up to date with what's happening on the Lawlands front, then please subscribe to the newsletter. That is all in the description. Click on through if you definitely want timely updates, more information straight to your inbox, as well as what's happening on the Lawlands front. One more thing to keep in mind for anyone out there that are part of the accredited worker visa scheme, please make sure that you tune in next week, because that is all I'm going to be dedicating a whole entire episode to, is all of the changes to the accredited employer work visa. Now, getting into what we're actually here for, which is the changes that are being proposed. The first piece of legislation that will be heavily amended, if it goes through, is the Employment Relations Act. And changes to the personal grievance threshold was the first thing that came out. And everybody was going, this is crazy. I saw lawyers posting about it on LinkedIn. Everyone was freaking out. But guess what? Australia's already implemented it, and we can see that it kind of works. So sorry about the spoiler alert. I personally practice in Australia and New Zealand in my day job as well. That is what I have to do. And I have definitely seen the benefits of this threshold. When I'm talking about this threshold, you must be going, if you've not heard about it, what are you talking about? So the end of last year, Minister Brooke Van Velden, who's the Workplace Relations and Safety Minister for the coalition government, basically she announced that a cabinet decision had come through to introduce an income threshold of $180,000 for unjustified dismissal claims. Right now, for example, anyone and everyone who has grounds to a claim, they are able to go ahead and raise that claim. So if you have grounds to raise an unjustified dismissal claim, an unjustified disadvantage claim, you can push on ahead and you can go through and raise that claim because you have the grounds to do so. It doesn't matter if you earn $500,000. It doesn't matter if you earn $50,000. You can raise that claim as long as you have justified grounds. Now, in terms of this proposed change that's going to come out, what the minister was saying was that employees earning over $180,000 annually won't be able to raise a personal grievance claim for unjustified dismissal. Now, why did they pick 180? They're saying that the $180,000 threshold aligns with the top income tax bracket, and they're proposing to adjust this every year based on average weekly earnings. Now, Australia does a very similar thing. Every year that kind of ticks over and that passes, you will see that bracket or that threshold will increase slightly. It's $180,000 base. So in your employment agreement where it says remuneration and it talks about how much the person will get annually, that is what should say $180,000. And that's when you know that they've met this bracket. Now, it's important to understand that employees can still raise other types of grievances. Just like in Australia, you can still raise one for adverse action when you're talking about discrimination. So regardless of how much you earn, that option is still there. And something that I believe has been lost in this entire discussion and debate online is that one thing that New Zealand is suggesting is that employers and employees can actually voluntarily opt back in to dismissal protections in their contracts. What the coalition government is doing is they're creating a negotiation type scenario and a bit of bargaining that can happen between an employer and an employee. And I truly believe that high threshold employees are typically more equipped to negotiate robust contracts. In those scenarios, you would assume, and I know it's bad to assume, but you would assume that they would have seen enough contracts to be able to call things out. And I normally notice that personally when we have somebody that's a high income earner, they will pick apart the contract a lot more than somebody that earns maybe 50 to 60K. Now that's a whole issue in itself in terms of needing to know what to look out for and what not to look out for. And that is another thing that Lawlands will be introducing, but I digress. Now it is still a major thing and it will create issues. You want to get somebody on board and all of a sudden you're saying to them, hey, yep, no, that's fine. We'll add that clause back in. And maybe they kick up a fuss later and now you're regretting it. There is a bit of a balance and it is important to understand what you actually want to do as an employer. But I guess the question is why introduce this change, right? What's the reasoning behind it? And the government has argued that it's about flexibility, efficiency, and getting the right people into high impact roles without employers fearing costly dismissal claims if things don't work out. As many of you know, like I said, I work across both jurisdictions and Australia has already implemented this. And this is what's happened in Australia. The data that's coming out of Australia is the same thing, that there's fewer unjustified dismissal claims from high income earners. There is, though, something to keep in mind. Because you have closed off all types of claims, and keep in mind, New Zealand won't be the same because you can still opt back in voluntarily as long as you negotiate and bargain that. At the end of the day, if you completely cut everyone off from being able to raise a claim in its entirety, there's generally going to be an increase in discrimination or harassment related grievances. Essentially, it's employees maybe trying to reframe their dispute and trying to fit that in with what they can actually claim. In Australia, if we took an example, let's say we had a senior executive earning just over the threshold and they raised a discrimination claim when they were dismissed, arguing that the termination was due to their age rather than their performance. That is the kind of issues that we might start to see where they try to angle their claim in a different way. For me, like I said, I always say I am a lawyer for employers. I'm here to help businesses and I am somebody that is always supporting an employer. Doesn't matter what goes wrong, but we are here to learn, understand, and navigate this crazy space of employment law. And for me personally, I do really welcome this change for employers. I know for many of you out there, it might not sit right with you. This year, I have been a bit more committed to being a lot more straightforward about what I believe in. And I know that a lot of people don't like that side of things, that it's more employer friendly. But at the end of the day, I truly believe that employers should be able to get on and run their business commercially. And I understand it's uncomfortable because this is very different to the principles around the Employment Relations Act. So the next change to the Employment Relations Act is around the termination of employment by agreement. It's a bill that's been proposed and it allows you to be able to have that discussion, to be able to speak to your employees. At the moment, if you want to approach an employee and have an off-the-record conversation about a breakdown in the relationship. So let's say, you hear about without prejudice conversations all the time. And a lot of times you might go to a lawyer or an advocate or somebody providing you with some sort of advice. And you might say, look, can't I just have a chat to them and tell them that they're no good and that they need to leave? And a lot of times you'll get pushback, probably 99.9% of times you'll get pushback. And it will be that, no, you can't just say that. You need to make sure that you have a conversation with the employee where it doesn't seem like you're pushing them out or giving them an ultimatum. It needs to be really based on the breakdown of the relationship or there has to be some dispute underway. If you were to have these conversations outside of these kinds of contexts, then usually the employee can raise a claim for unjustified constructive dismissal. What that means is they might say that they were forced to resign, or that they were provided an ultimatum for them to either resign or to be terminated. So if an employer offers an employee a settlement to end the employment relationship, this won't automatically give rise to a personal grievance in this case. What that means is that employers, this could be a massive game changer. You could effectively have a breakdown in an employment relationship and it just might not be working with an employee. I'll give you an example. I dealt with the case many years ago. I remember the clients vividly because they were the most lovely people. They had just come in and taken over their mum's restaurant for a certain time period. And what they wanted to do was have a chat to this employee who was virtually doing everything they could to really break down this employment relationship. It just was not working. And in the end, they just said to me, "Can I please have a frank conversation?" And they weren't in a disciplinary process. And if I had advised yes, it would be unfortunately a high risk situation. In this scenario now, and with the proposed changes, if this goes through, that means that you can just have a frank conversation with your employee. If there is a settlement that you're looking at, and let's say that this employee is lying, they've stolen, they've consistently done something wrong, and you know that there has been a true breakdown of trust and confidence, there's just no way to come back from that, then it's important for you to be able to have a conversation with them rather than worrying about a personal grievance being raised. There will be always, as there is, some concerns that these proposals are not easily aligned with what is in the Employment Relations Act. And we'll see as this kind of goes through what will actually happen and transpire in this space. But I do believe that this will allow for a lot more of an open and frank conversation rather than letting this linger and fester and doing months and months of processes where the employee is really hating the workplace, the employer is hating the situation, and they just want things to end. So it might be a very positive one. Now, the next thing was changes to remedies. Minister Brooke Van Velden has also said that the Employment Relations Act will be amended to give more consideration to an employee's behavior in the context of remedies for personal grievance. One of the things that an employee will get to try and fix the situation or rectify the situation or give them some sort of value for the hurt and humiliation they've gone through is compensation. Another thing might be a reinstatement. There's lots of different remedies that the Employment Relations Authority or the employment courts can actually award and determine for an employee to receive. In the context of personal grievances, I've done an episode on compensation as well, just to explain how that works, but that is one of the key remedies that we see time and time again. What this new change is actually proposing is to completely eradicate and get rid of an employee's right to a remedy if their behavior constitutes serious misconduct. I know. Isn't that crazy? But it's such a good change. This is where this new piece of proposed legislation, keep in mind not in effect yet, is going to prohibit an employee from seeking reinstatement and compensation for hurt and humiliation when their behavior has contributed to the issue at hand or the dispute that's there. At the moment, also keep in mind that there is also factors that are weighed in around an employee contributing to their grievance claim. Now, usually what that means is a discounting of the compensation, but what the coalition government is proposing is to remove the right entirely to a remedy. That means that if your behavior constituted to serious misconduct and you were a huge part of that as an employee, then you don't get reinstatement and you don't get compensation for hurt and humiliation. Massive change. And like I said, now it's mostly the authority member kind of sits there and goes, okay, so it seems like you did this, this, and this. That's not okay. So we will take off 10,000 from your compensation, but you still get 35,000. Of course, with employment law, things are always grey. So I'm sure as cases come out, it will be a little bit more confusing and the arguments will get a lot more interesting. But what this is proposing to include is stronger employee accountability. And what we see in a lot of cases, if you read those authority cases, is that the employee, yes, they contributed to this. And yes, process was botched and flawed on behalf of the employer, but the employee was still hurt, humiliated, X, Y, and Z, and therefore they get this amount of money. But what this is proposing is that even even if something went wrong along the way, if the employer acted in good faith and tried to adhere to good faith obligations, that the employee won't be able to access that reinstatement or that compensation. This will also apply to cases where there is poor performance, and that's what's contributed to the grievance. And the minister has also signaled the following more technical changes around the way that an employee's conduct would be considered when awarding remedies. So the first one is a reduction in remedies. So like I said, they're saying that they're going to limit or completely eradicate that remedy. It's very clear here that the authority and the employment courts will be empowered to reduce remedies by up to 100%. So they will be given the power to 100% reduce that remedy. So make it zero. We'll see how much they will do that, because at the end of the day, like I said, a lot of these changes are viewed as bad faith. They are being seen as being a negative impact on an employee and a negative impact on the employment relationship and the essence of what the Employment Relations Act is. Another technical change that they were proposing was around obstruction consideration. So this was around the authority and the employment court considering if the employee obstructed the employer's ability to meet their obligations. What did the employee do if they did anything in that scenario to actually stop the employer from meeting their good faith obligations or do the process correctly? And the third thing that they are considering as a more technical change is that there is a higher procedural error threshold. So employers in this case will face less risk of remedies if they acted fairly, even if minor procedural errors occurred. This right here is where I think the difficulty will lie. How are we going to define what a minor procedural defect is? What is being proposed here is that even if there were these minor procedural errors that occurred, the threshold for procedural error will be raised where the employer's actions are fair in all the circumstances. It really is trying to redefine what is a fair and reasonable employer. It'll be interesting because as the cases come out, maybe we'll be able to see a little bit more tightening around what that actually means. So I just wanted to provide you with some examples the coalition government provided around why they've put this forward. So the first one is an employee was dismissed for falsifying information on their timesheet, yet she was able to receive $10,500 in compensation and 13 weeks of lost wages from their former employer. Another one is a healthcare professional was dismissed for being physically violent towards a patient, yet was still reinstated into their role following a successful personal grievance. I have personally seen this time and time again. I even dealt with a case many years ago where a woman physically hurt a child in a daycare facility and they were still able to come back into work, still reinstated. It was awful, awful, awful. An employee who was dismissed for theft of company food still received $21,000 in compensation from their former employer. These are some examples of real world cases that have happened that we've seen, and I have seen many, many variations of the same thing across my time working in employment law. So let's keep it moving. There is another change to the Employment Relations Act, a little bit outside of the personal grievance space. It's around restraint of trade. This was first introduced in September 2022. And I really genuinely thought that this wouldn't go through. It's because this particular bill was introduced by the Labour government, and under the coalition government, a bill like this probably wouldn't be seen on their agenda. It nonetheless has gone through. It is at its second reading, and what it's trying to achieve in more detail is that it will provide that restraints of trade have no effect wherever an employee earns less than 3 times the minimum wage. So if you earn 3 times the minimum wage, then yes, you will be able to be bound by a restraint. But if you don't earn that much, and if you don't have such a high income, then no, there is no restraint. And yes, a restraint of trade is great, but there are so many people that are worried about business secrets and all of these things moving around from place to place. But you need to understand that it is very anti-competitive to stop an employee from moving around unless they really hold a lot of sensitive information that can actually impact the business's positioning in the market. That's where you can truly see that a restraint is required. Another thing that the bill is proposing is to limit the use of restraints of trade to those situations where the employer has a proprietary interest to protect. So like I said, what are they trying to protect? What cannot go over to another employer? And keep in mind that there are also other clauses in there around solicitation, all of those things. This is usually the one where you are doing a true restraint of trade. You cannot go and work for anyone within 10-kilometer radius for X amount of months. That is what the restraint that we're talking about is. Another thing that will be proposed as part of the bill is to require employers to pay employees who are subject to a restraint provision an equal amount to half of their employees' weekly earnings for each week that the restraint remains in effect. If you are actually going to be placed on a restraint, and let's say you are one of those ones that earns 3 times the amount of the minimum wage, then you will now, as an employer, need to potentially pay to make sure that the restraint is in place. And that means half of the employee's weekly earnings for each week that you keep the restraint in effect. You can limit the duration of the restraints to no more than 6 months. So no more 12-month restraints for all of New Zealand. This will look a little bit different. As you can see, the main aim is that the bill will prohibit the use of restraints of trade in the employment agreements for lower and middle income employees. This is what the whole purpose behind it is. Let's see how this kind of unfolds and where this goes. Now, the last few changes that I wanted to talk about was around the minimum wage increase. Now, we saw huge hikes to the minimum wage increase under the Labour government. Now that the coalition government has come in, we saw a modest increase in 2024, and then we saw another modest increase being introduced and proposed for this year. Right now, the current minimum wage is $23.15. MBIE does normally, so the Ministry of Business, Innovation and Employment, they do provide recommendations on what the minimum wage should be. It did suggest to do a 2% increase. That would take it up to $23.60. And they believe that was the best balance between the government's objectives as well as making sure that it would protect the real income of low-paid workers while minimizing job losses. What did the coalition government come back with? They said that a 1.5% increase will reflect the current economic environment that we're in and the labor conditions that we have. All in all, what does that mean? My long-winded spiel is that on the 1st of April this year, so mark your calendars, people, the adult minimum wage will increase to $23.50 per hour, and the starting wage and the trading wage will also get a little bump as well. All right, and we are now approaching our last change. Okay, so on December 13th, right before Christmas and New Year's was coming on through, Minister Van Velden announced that the government recently conducted targeted consultation. So we had reached targeted consultation over the Holidays Act. We were looking at a draft bill and there was a lot of feedback that was coming through. What Minister Van Velden basically said was that, look, I've listened to everyone's feedback and asked officials to begin work on a lot of different areas like hours-based accrual for annual leave. They've also looked at the greater simplicity that can be achieved by having a more simplified system. In the coalition government's view, in Van Velden's view, it is not enough to have a workable legislation. They really truly are trying to strive and aim to reduce complexity and compliance costs as much as possible. And hours-based accrual has the potential to achieve a much greater focus on simplicity. So what does that all mean? It means that it is still their ambition and their goal to pass a new act by the end of their term, but that means revisiting, revamping, and actually going in a lot harder on this bill. This Holidays Act is a long way away from being overhauled. They are in talks now of revamping and looking at cabinet decisions in 2025. Like we've been saying for maybe 5 or 6 years, the Holidays Act is still going through its overhaul. Don't hold your breath, everyone, but hopefully we will hear more in 2025. Now, that is basically it from me, everyone. And I wanted to say, in terms of a big takeaway here, 2025 is shaping up to be a year of massive changes in the employment law space. Employers, you need to be ready. Keep in mind, there are no changes right now, but they are around the corner. So hopefully this has helped you understand the landscape. I always like to know about the employment law updates to see the trends and the patterns of where things are headed. If this comes all into place, it'll be great to see how the landscape changes. We don't really know. It's all hypotheticals and predictions and ideas. And yes, we can look across the ditch to Australia and see what they do. But at the end of the day, until we do it ourselves in our framework, in our context of legislation, in our context of the Employment Relations Authority and the employment courts, we won't really know how it all plays out. If it feels all overwhelming to you, remember you're not alone when you're navigating these tricky conversations or you're looking at the Holidays Act. We are here to help. Lawlands is here to help you stay ahead of the curve. So if you've got any questions about today's episode or any questions in general, then feel free to reach out to me on LinkedIn or even send me through an email. And don't forget, like I said, to subscribe to the podcast for deep dives into all these kinds of changes and all these discussions. Please remember, again, just to do another mention, that next week I will be discussing all of the changes to the accredited employer work visa. So just make sure that you are tuned in for that. If you are somebody that hires migrant workers, then it is really important to understand the changes in that space. I am so excited to kick off this year. Thank you so much. I hope you have a lovely day, night, evening, morning, whatever it may be. And guess what? I'll catch you in the next one, everyone.